welcome to everyone, at least in Central New York. It is a beautiful Tuesday afternoon in May. We have a wonderful program for you that is packed, so I want to get right into it. Before we get started, though, I do want to make a quick plug for our workplace investigation seminar that we are going to be putting on Thursday, June 9th at the DoubleTree by Hilton in Syracuse. We hope to have registration open for that today or tomorrow. Registration will be on our website, and we will put the link in our PowerPoint presentations during these Tuesday weekly webinars going forward. All right, Kathy. Now, let's start off with our weekly COVID update. I thought it would be interesting to put the data that we have from 1 month ago and compare it with today's data. You see that as of April 11th, the daily average of cases in New York State was just a shade under 5,000. That has gone up significantly in the last month. We now see that it's approximately doubled to just under 9,500. So significant changes in the wrong direction, unfortunately, in terms of COVID cases in New York State. Next slide, please. And again, we compare April 11th with yesterday, and we see that we're trending in the wrong direction again. More orange, more red. The numbers are not looking favorable in New York State. Next slide, please. This provides a little more breakdown for you by county and area. You can see that the hotspots have changed a little bit. You don't see Onondaga County on that list that we saw in April on April 11th. We see more Western New York and Eastern New York. Central New York was the significant hotspot for a little bit there, but it has expanded to other parts of the state. Now, I will point out very quickly that we still haven't seen any changes in the masking rules or requirements or the quarantine or isolation rules or requirements. If you recall, we've updated you pretty regularly on those changes. We have seen pretty consistently the same rules for the last month and a half, 2 months. Nothing's changed yet. It'll be interesting to see what the state does if the numbers continue in the wrong direction, but no changes as of now. All right. Now that I'm done giving you the quick update on COVID, we have some really great presentations for you. These are, or most of these presentations are based on your comments. This one in particular is something that we have heard a lot about from clients. What makes a good employee handbook? So here to talk to us about that today is Stephanie Fedorka. You all know Stephanie. She's been on this webinar many times before, talking about lots of different issues. Stephanie does a lot of work with employee handbooks. So you're going to hear from Stephanie now when I turn it over. But if you have any questions after the webinar going forward and you're thinking about redoing or revisiting your employee handbook, Stephanie is the person to call. So Stephanie, please take it away.
Thanks, Adam. Thank you so much to everyone for being here. It's great to be in front of you again and talking about a topic that's very near and dear to my heart, as it's a big part of my practice, and it's what makes a good employee handbook. And I'm gonna give you my 5 keys, which are not all of the keys certainly, but I think these are the 5 things that I try to keep in mind of what makes a good employee handbook, and some practical tips and pointers for you all if you are considering revising your employee handbook, if you're in the middle of an employee handbook review project, or if you don't have a handbook, and what you need to get started or what you should be thinking about if you're going to create an employee handbook. So before we get into tip number 1, I like to think of the employee handbook as a tool in an employer or in management's employee managing briefcase or a toolbox. There is no state law or requirement to have an employee handbook. I think that's important to note, but it's very much a best practice. Why is it a best practice? Because there are a lot of policies that you do have to have in writing by several different laws, under several different laws. And the handbook is a great collection of and a great resource for your employees and for your administrative folks who are administering and enforcing your policies, as to what exactly your policies are, and they all live there. It's one of the first documents that you're going to give to new employees when they're hired to get familiar with your organization, with your policies, with your procedures, with benefits to some degree. So I think it's a very important document, and that's why we're going to go through some of my key best practices and keys to having a good one. So first and foremost, knowledge and understanding. Know what's in your handbook if you have one. What policies are not in your handbook, right? It's important if you're in HR or if you're another manager or a supervisor or other administrator or in some administrative management capacity to understand what the company's policies are and what's in that handbook. Understand the must-haves, the should-haves, and the extras. These are all going to depend based on industry, employer size. A big question I get is, can you give us a list of what policies you have to have in your handbook? And unfortunately, it's not that simple. It's going to depend largely on where you're operating, again, what your industry is, your employer size, the location of your employees, your operations and your own practices, concerns and issues that you've maybe learned from past experience, and other best practices depending on what your operations and what your industry and business needs. So thinking about these three buckets though, your must-haves, your should-haves, and your extras. It's important to work with legal counsel to understand both what you need and to review any policies to make sure that any policies that you have drafted or prepared are in compliance with applicable laws, or if there are any other concerns with respect to what your policies are that you're including in your handbook and your practices. Understand and plan how policy changes will be implemented. If you are doing a big overhaul in your employee handbook or you're changing something drastically, I think there's a lot of reasons for change, right? Whether it's a law, whether it is a need for recruitment and retention, DE&I missions and initiatives. So depending on all of those things, understand and plan how any policy changes are going to be implemented. That's going to include things like communication, rollout, if there's a transition period, if there's any other limitations. For example, if you're in a unionized setting, you don't necessarily and you don't generally have the authority to unilaterally make changes to terms and conditions of employment. So understanding that while you might have an employee handbook, what you have in your collective bargaining collective bargaining agreement rather, is going to govern. And just because management wants to implement a certain change is going to be dictated on what is in that employee or collective bargaining agreement, as well as what the applicable labor law states, whether you are a public employer or you're a private employer in a unionized setting, and what's a mandatory subject of bargaining or not, and what types of management rights you've reserved or negotiated in your collective bargaining agreement. Employees in different states as well. If you have remote workers, which is becoming increasingly more common these days, I think since COVID, we're seeing much more recruitment and hiring of remote work and remote workers in various states. Understanding that there may be some limitations and some additional policies and procedures that you might have to have in place with respect to those employees, right? Do you need to have specific policies for those employees that might apply? Do you need to have a supplement to your handbook that is specific to those other states that you are not necessarily brick and mortar shop in? So understanding those things are going to be critical to having a good employee handbook. Second, plain English. I can't emphasize this enough. Don't undervalue the importance of writing policies in plain English. Know who your audience is, who are your employees. If you have different employee handbooks for different operations or different groups of people, right? Writing them in a way that they can understand, whether that means, that you have employees who don't speak English, right? There might be a critical importance to having an employee handbook that's translated into that other language, or other practical reasons for having or writing in plain English, right? You want to make it understandable. You want to avoid legalese and avoid overcomplicated grammar or word choices, because at the end of the day, less is oftentimes more. And I think the whole point of having your policies is for both the employees to understand what the expectations are or what the policies really mean, and to avoid confusion so that there can be no misunderstanding as to, I didn't know this was the rule, or I didn't know that this was how that worked. And for whoever's administering your policies and enforcing those policies, that there's no question as to what this policy means and what the policy and procedure really is or intended to be. Third, stay up to date. Changes in labor and employment, as we've seen, can happen fast and frequently for a number of reasons. So try to keep your employee handbook up to date, again, reasonably. I'm not saying, and I appreciate that it isn't possible to be updating it every single time something might change. But I think it's a best practice to try to have some routine or some consistency in updating it with some degree of frequency, as opposed to updating it once, putting it down, never touching it again for 10 years, and then going through and having to face the overwhelming challenge that is to give a whole makeover, complete overhaul to your employee handbook, since policies may be outdated, or maybe new policies that you need based on changes in laws, et cetera. So consider making changes, or consider keeping a list of some sort to track changes if there's changes in your operations or changes in your policies, changes in laws requiring new policies, or changes in existing policies that might be required as because of the changes in the new laws. Other compliance concerns and issues that might be considered if you need to make changes in order to comply with new obligations or other expectations or arrangements, agreements. And again, to avoid total makeover, complete overhaul, by conducting more frequent and consistent periodic reviews, right? This might be once a year, you do a quick check and say, okay, what has changed in the last year? Do we need to make any substantial changes to our handbook? And then incorporating that, as opposed to doing an entire makeover every 7 to 10 years, where several things may be out of date, or they might just not be your practices anymore. 4, don't over legislate. You can't predict or account for every single possible scenario or situation. So sometimes it's difficult, and we want to be very specific about what's going to happen. If these things happen, if A, B, and C occur, this is what's going to happen every time. But unfortunately, in labor and employment, that might not necessarily be a one-size-fits-all model. You generally want to have discretion to consider all of the facts and circumstances in the given case or the situation. So you're going to want to keep policies and management discretion broad generally. Most commonly, I see these issues in disciplinary procedures or zero tolerance policies. Zero tolerance policies are generally fine in most regards, but it leaves little room for management discretion to determine and evaluate all the other circumstances and facts, which, again, that might be something that I generally recommend, to have that discretion so that you can say, okay, this was the particular set of circumstances, this warrants this type of discipline, or this is more appropriate in this circumstance, as opposed to having no flexibility and having to comply with your policy language. Benefits, avoiding promises or guarantees of any benefits. If you're going to include some language about benefits in your handbook, making sure that they're general and you're referring to the official plan documents that control. You're not guaranteeing any benefits for any duration of time, etc. So again, a couple of examples of where over legislation may tend to occur. And again, understanding and accepting that you can't predict every single outcome or scenario, and sometimes it is better for you to leave it somewhat broad while you're complying with the law, but allow yourself to evaluate, to have the discretion to evaluate each situation as it arises. And last, customization and tailoring your policy or your handbooks. Handbooks should be tailored to your actual policies, procedures, intentions, and operations. One size certainly does not fit all, as I noted early on in the slides before we kind of dove in. Templates are a good starting point, but they should always be reviewed and tailored and customized to whatever your needs and wants are, right? Balancing both compliance with the law and what your particular operations and business needs are, because there isn't always a bright line rule in labor and employment law. There's certainly, I think more oftentimes than not, is a gray area. And there is some flexibility and some discretion for employers to develop policies that make sense for them and for their operations. So use legal counsel to customize your policies and to understand what might be permissible. Again, that balancing act of compliance with what's lawful, and then balancing what your needs or wants, concerns are, and in terms of your operations and your employees and your workplace. Legal counsel is also going to be able to provide advice on best practices. So while something may not necessarily be unlawful, there may be other considerations as to why perhaps there's a different way or a better way to do it, or another approach that you should consider to avoid unintended consequences. So I'll leave you with my final piece of advice, right? Your organization and policies are inevitably going to change. Workplaces are inevitably going to change, whether it's because of a pandemic that really rocked how a lot of businesses operate and organizations operate, or if there are changes in laws, or you're growing as an organization. So don't leave your handbook behind in the dust, and try to keep it up to date best you can. And like Adam said, if you have any questions or concerns, don't hesitate to reach out, and we'll be happy to help you along your handbook journey.
Stephanie, thank you so much. Great insight, great advice for all those employers out there. All right, next up, we have a higher education update from Sandra Casey, who you have heard from before on this webinar. So Sandra, welcome back.
Thank you, Adam, and good to be here, everybody. It is also sunny in Albany, New York, and I'm enjoying the warm weather, finally, after the very cold spring. So next slide, please, Kathy. I wanted to bring to your attention a new law that recently was signed by the governor last week, which adds a new section to the New York State Education Law, Section 640, which prohibits degree granting institutions and licensed private career schools from withholding transcripts of students who owe a debt to the institution. It's also unlawful under this new law for institutions to condition the release of a transcript on the student's payment of the debt. And also, institutions may not charge a higher fee or provide less favorable treatment of a transcript request because a student owes a debt to the institution. Next slide, please. So the law is going to be overseen by the Department of Financial Services, and the Superintendent of Financial Services can impose a penalty of $500 for each violation an institution has been found to have committed after notice and hearing. Furthermore, individuals who have been injured as a result of the prohibited practices under 640 may bring a civil action against an institution to enjoin practices that are violative of the law. And the court can award reasonable attorney's fees to the prevailing plaintiff. So there's a lot at stake here. The new law is effective as of June 3rd, 2022. Next slide, please. So I reported to you back in March that the governor proposed similar language in her proposed budget in Article 7. The difference in the governor's language and the law that just passed and enacted is that the governor gave the Higher Education Services Corporation authority to suspend, limit, or terminate a school's participation in state financial assistance programs such as TAP for any violation. So that's significant. And it shows the governor's feeling toward transcript withholding. And but that particular, her particular language was eliminated from the enacted budget. So we're left with this new law. Now, given the governor's hard line on transcript withholding, I would caution schools about using the transcript at all in collection efforts. For instance, putting a transcript notation that the student owes a debt on the transcript might be seen as treating the student's request for a transcript unfavorably and a violation of the law. Also, withholding a diploma of a student debtor, but not the transcript, may also be risky under the law and could possibly be a PR nightmare for the institution, given all the attention this has been given in the past few months. So colleges really should consult with their attorneys and with their communications office on any practices withholding acknowledgement of credit the student has earned, the student debtor has earned. But that's not to say that schools can't take collection efforts or use collection efforts. For instance, I mean, a school could block a student's registration for the next or for the following semester. There's nothing in the law that would prohibit that. Schools should really just focus on collection efforts that mitigate the amount the student incurs in debt. Doing counseling, reaching out to the student often to keep the debt clear would be, most encouraged. I mean, because that's where best practices are going to come into play. And, not trying to do anything to harm the student's ability to get employment, to go on to graduate school. And, again, using that transcript as a tool, as an enforcement tool is a no-no. So next slide. So as I reported this past March, there were provisions in the governor's law under Article 7 affecting higher education generally. These provisions were subject to negotiation during the budget process, and a few made their way into the enacted budget. Next slide. So for TAP, there was limited availability for TAP for part-time students. TAP was available for part-time students who earned at least 12 credits in each 2 consecutive semesters, were enrolled at least 6 credits in an approved undergraduate program, and had a GPA of at least a 2.0. The enacted budget eliminates the requirement that the student must have earned 12 credits in 2 consecutive semesters, and only requires the student to be enrolled in at least 6, but less than 12 semester hours or equivalent in an approved undergraduate degree program and have a GPA of at least a 2.0. So that was opened up quite a bit for part-time students, and that's something that's going to open up a lot of aid to students in New York State. Next slide, please. And the enacted budget also expands part-time TAP to those enrolled in an approved non-degree workforce credential program at a community college, which program leads to the employment or advancement of a student in a significant industry, as identified the New York State Department of Labor in its 3 most recent statewide significant industries report published preceding the student's enrollment in such program. And another biggie with regard to TAP is that TAP was restored for incarcerated students. Years ago, back and then before the 90s, incarcerated students were eligible for TAP, but that was eliminated in, I believe, in mid-90s, 1994, 95. And after many years now, it's been restored in the law, and incarcerated students can avail themselves of TAP. Next slide. The enacted budget also includes the governor's proposal for campus polling places, specifically where there are 300 or more individuals registered to vote on contiguous college property. There must be a polling place on such property or at a nearby location recommended by the college. So this is going to beef up voter turnout. Next slide, please. There was also language in the governor's proposed budget to streamline some program review by the New York State Education Department, but that language was eliminated from the final enacted budget. Also eliminated in the final budget was a proposal to transfer all functions of the New York State Education Department relating to oversight of healthcare professions to the Department of Health. So that's no longer an issue for us. And I believe that concludes my remarks. Went pretty quickly. Thank you, Adam.
Thank you, Sandra. Always very helpful. Okay, next up is Nick Jacobson. Nick is an attorney out of our Rochester office. He is in our labor and employment department and is going to talk about something near and dear to my heart, which is employment litigation trends. So Nick, take it away.
Thank you, Adam. Next slide, Kathy. Thanks. So over the past couple of years that we've been coming to you on these Tuesday webinars, between March of 2020 and March of 2022, there were over 5,000 state and federal lawsuits filed related to the COVID pandemic. As you can see, we've got a breakdown of the top states where those actions were filed. In California, where there was a lot of state legislation related to the COVID pandemic, there were over 1,700 cases filed. Here in New York, we were on the list at 409, New Jersey slightly above us with 473, and our friends down in Florida with just under 400. One important thing to note is that these case numbers are only for state and federal lawsuits. They wouldn't cover actions filed with state or federal agencies like the EEOC or the New York State Division of Human Rights. So these numbers are actually a little bit underrepresentative, but I think they give a pretty good idea of just how prevalent COVID-related litigation has been over the past couple of years. Looking at a breakdown of the cases that were filed, over half of them included a claim of retaliation. Disability discrimination, as you can imagine, was also another frequent claim, with over 2,000 disability discrimination claims being filed related to COVID. One important thing that I want to note, and this is going to be the case throughout the statistics we're looking at today, just looking at the retaliation and disability discrimination numbers, you'll note that it does get up over that 5,000 case number. But for instance, if an employee requested a disability accommodation and then was terminated shortly after, they might bring both disability discrimination and retaliation claims. And so their case would be represented in both of those numbers. Specific to the new COVID legislation, there were over 1,600 cases filed alleging violations of the FFCRA and FMLA. And another frequent COVID area where we saw a lot of COVID-related claims was in the wage and hour area, likely as employers tried to respond to juggling schedules and implementing remote work and other things to try to accommodate employees being on leaves and the workplace restrictions that were implemented due to the pandemic. Another important thing to note is that over 600 of the 5,000 COVID-related lawsuits that were filed were class action lawsuits. Next slide, please. So class action litigation. Courts issued more rulings in workplace class action lawsuits, and plaintiffs recovered more money in settlements in 2021 than ever before. During 2021, there were 1,607 rulings issued by courts in class action matters, and plaintiffs recovered over $3.62 billion in settlements. That's a huge increase from 2020, when they recovered just $1.58 billion, and 2019 when they recovered $1.34 billion. The number one area where we're continuing to see class action litigation is in the wage and hour area, which is to be expected because if an employer has a wage or hour policy that's non-compliant, it's going to affect every employee or could affect every employee in the workplace. Or at least a large portion of the employees in the workplace. So those types of claims often lend themselves to class action litigation. Another area where we're seeing a lot of class action litigation is related to COVID, and these cases have been prompted by return to work programs and things like vaccine mandates in the workplace. We also expect the trend of increasing class action litigation to continue, given the prospect of more government enforcement actions. Next slide, please. One of the agencies where we're expecting to see more government enforcement actions is the EEOC. In 2021, the number of charges filed with the EEOC actually fell 9.1%. From over 67,000 in 2020 to just over 61,000 in 2021. That makes very good logical sense given that in 2020, a lot of people might have found themselves out of work or furloughed due to the pandemic. whereas in 2021, we were seeing more people returning back to the workplace. Here in New York, the total number of charges fell 14% from just under 3,000 to just over 2,500. In New York, it's also important to remember that because we have the New York State Division of Human Rights, which is a comparable state agency, that we typically see less claims filed with the EEOC because there is a state analog that employees can turn to. Like with the COVID-related litigation, the most common claims were retaliation and disability discrimination related claims. And you'll see that that's the case throughout, regardless of where claims are being filed. Race discrimination claims were also included in just over a third of the cases that were filed. Additionally, while overall the number of charges fell 9.1%, we did see increases in some areas. We saw an increase in claims for discrimination based on color, national origin, and race. Next slide, please. So recovery for claimants through litigation trended downward from 106 million in 2020, which was a record high and really kind of an anomaly, back to 34 million, which is more typical. Recovery through resolution actually increased over the past couple of years, though, in the last year from 333 million to 351 million. And that makes sense given the high number of cases that were filed in 2020, many of which were resolved during the 2021 year. There were more merits findings for claimants before the EEOC over the past year. The percentage increased from 17.4% to 19.2% in 2021. The EEOC also filed more merit suits on behalf of employees, filing 116 in 2021, up from 93 in 2020. The EEOC has cited the increased numbers of merit suits and also the increased number of merits findings for complainants. And they attribute that to increases in the number of employees, allowing for more thorough and comprehensive investigations, and also increased funding, which allows for additional merit suits. So we can expect EEOC enforcement actions to continue to rise over the next year. The EEOC added a number of employees over the past year, particularly attorneys, to increase their enforcement efforts. And they plan to add about another 200 employees over the next fiscal year to assist with their goal of increasing enforcement actions. Next slide, please. Here in the New York State Division of Human Rights, as you know, many employers in New York recognize things are changing in the division. During the fiscal year of 2020, just like with the EEOC, we saw a huge spike in cases. That year, there were 6,300 new cases filed, with only 5,800 being resolved during that year. Over the past years, the numbers got better with over 3,600 cases being filed, but over 4,100 being resolved. So that is positive news that there were more resolutions than cases filed, because there is quite the backlog of cases right now before the Division of Human Rights. And that has led to an average processing time which now exceeds 570 days. You may remember prior to the pandemic, claims would often be resolved within a year if they're filed before the Division of Human Rights. And that was seen as a benefit for employers or employees who wish to file, was that there would be a relatively quick turnaround if it was filed before the New York State Division of Human Rights. Certainly a quicker turnaround than if they had chosen to file in state and federal court. Now that's not so much the case. There's currently almost 3,900 active cases, although again, that number has improved since 2020. 2,200 of those cases are currently in the investigation phase, and over 1,600 are currently in the hearing process. Next slide, please. One caveat I do want to throw out while we're going through the New York State Division of Human Rights statistics is that while employment cases do predominate the caseload of New York State Division of Human Rights charges, there are about 17% of the complaints which relate to housing discrimination, which could skew the numbers slightly. Another thing that I want to point out is that the New York State Division of Human Rights has also adopted new rules regarding settlements, particularly settlements after a probable cause determination has been issued. For cases filed after October of 2021, the rules apply, and they, like other rules that apply, have been implemented, make it more difficult for employers to get confidentiality of settlement provisions. While the division has implemented rules which, in my opinion, discourage employees or employers from settling after a probable cause determination, we've seen the numbers of probable cause determinations actually increase from 15.7% in 2020 to 21.4% in 2021. Part of that is anecdotally, it does appear to be a policy shift where, possibly due to the increase in caseloads, cases that may not previously have been receiving a probable cause determination are receiving a probable cause determination now. But that also has a lot to do, I think, with changes to what the standard is for actionable harassment under New York state law, which was changed at the end of 2019. So as those cases are coming through in 2020 and 2021, I think that would account for some of the increase in the percentage of cases getting probable cause determination. Of cases going all the way to the hearing stage that aren't resolved during the investigation stage, 77% of those cases settled in both 2020 and 2021. Of the few cases that actually went all the way through to a determination after a public hearing, employers prevailed in 77% of those hearings in 2020 and in 91% of those hearings in 2021. Just as the case with claims filed with the EEOC and cases filed in state and federal court, disability discrimination and retaliation continue to be the most prevalent. And again, race and color discrimination claims were also widely represented. Next slide, please. And so just a few takeaways from our analysis of the statistics from the last couple of fiscal years. One important thing to consider is reviewing wage and hour policies to ensure compliance. Class action lawsuits are a real threat. The recovery is often substantially higher. The discovery at issue in such a case is also often much more wide-ranging. So wage and hour being the most common area, that's a good place to look to avoid a claim. Also taking special care to avoid retaliation and disability claims and consult with your counsel when necessary on those issues. And going forward, just again, to expect further increases in enforcement actions from state and federal government agencies. And that's the end of my presentation. Thank you.
Thank you, Nick. I really appreciate it. Okay, so what we were originally planning to do next was to have Jeff Keel and Lou DiLorenzo on to take some time to cover another great topic. Lou and Jeff have been presenting on these webinars now for the last couple of months. I don't want to cut them off and I want them to be able to have a full time with you to really dive into the topic. So I think what we're going to do is we're going to hold off on that topic for today, and Jeff and Lou will be back on in the near future. Thank you all for being with us today. We appreciate you joining us. If you have questions on any of the topics you heard about today, feel free to reach out to the presenters. You can always reach out to me. And we will see you next week. Thank you. Take care.